Mr. Scanlon, I turn to you.
Well, Mr. Chairman, you have before you the tabulated statement of returns and proclamation of results for the March 18th, 2014 general primary. And we simply ask that the board approve and adopt this tabulated statement, and we will then forward these returns to both the Cook County Clerk's Office and the State Board of Elections.
Okay. Is there a motion to approve tabulated statement of returns?
Can I just lodge a complaint about that? I don't know if it's in order or not, so I'm just asking that.
No, it's not in order, but yes, go ahead.
Okay, speaking for Defend the Vote, we would be concerned, and we have submitted a FOIA and have gotten insufficient results as well as insufficient responses from your staff regarding how your provisional votes were counted.
Let me just interrupt you. This is Sharon Meroni from Defend the Vote speaking right now.
Thank you
Go
very
right
much.
ahead, Sharon.
I appreciate that introduction and apologize for not making it myself.
That's okay.
So the concern that we have is the affidavit that each one of your provisional voter makes affirms that he is a resident of the precinct from which he is voting in. And so you have affidavits that are stating one thing, and if you are then counting that vote, we would like to have that as part of the record, because I believe that you would have an issue where a voter is stating he lives there and either he does or he doesn't. And if he doesn't live there, then he should not have given in a ballot in the first place. And I have written an extensive report about this. I'm also extremely concerned that voters may or may not have been made aware that their votes on the different judge positions, as well as on the many tiny referendum that were running through Chicago. You know, I'm not sure even how many votes are involved, because I couldn't get a response from this board in order for me to make a more prepared presentation to you.
Okay. So let me tick off those. So on the first one, and correct me if I'm wrong, Jim, but the Illinois Election Code provides the language with specificity that must be contained within the application for a provisional ballot. Is that correct?
It is, Mr. Chairman. But when the General Assembly amended the legislation in Article 18A to provide for the counting or the partial counting of provisional ballots cast in the wrong precinct, they neglected to go back and amend the language of the certification. So, you know, Ms. Meroni is correct in that the language in the certificate, in the affidavit, was not updated when the legislature amended the law to allow for a voter to cast a ballot in the incorrect precinct. But I don't think that you know, I doubt that the state's attorney is going to, you know, prosecute individuals on the basis of an outdated affidavit if it happens to be incorrect, merely because they're exercising a right that the General Assembly has now conferred on them, and that is to cast a ballot in an incorrect precinct. So, you know, I would hope that the legislature will go back and update it and correct it as it should have done in the first place.
So
well,
this happens.
That it's actually deeper than that, General Counsel Scanlon. The intention of the law is that provisional voting is in precinct only, and the directions that the election judges receive are very specific. They say that they first must confirm that the address of the voter is in the precinct, and then after they confirm that or do not, and if they cannot confirm it, then they are mandated by the law to send the voter to the correct precinct and send them out of the precinct.
Right.
So it makes an immediate problem in your polling places, because the judge here is told by the law, which is supported by 18A 2, which also says that the rules can't override these procedures. These are mandated. So the procedures say the judge has to send the voter out. Now the voter says, I'm going to insist. So now you have a conflict in your election polling places where the voter has a right to, you know, resist the mandated instructions by the judge.
Well, you're mixing a few terms here, but I'll go to Mr. Allen.
The policy of instructing the judges to advise voters to go to the correct precinct has been and remains the same. In fact, to that end, that is why one of the key reasons the board invested in electronic poll books, so that the judges of election would have the means to provide the voter with direction to the correct polling place. And to that end, we had far fewer calls this election as a result of the electronic poll book. Even as a percentage of calls, even if you factor in turnout, for people asking for where is my polling place, or judges calling on behalf of voters, where is this voter's polling place. The primary 4 years ago, we had 240 calls that we just logged downtown, and we had 60 this election. So the goal of the board and what we instruct the judges to do is to get the voter to the correct polling place, because we want to avoid provisional ballots. That being said, it has always been, again, consistently the policy of the board, that if the voter insists that they want to cast a ballot in that wrong precinct, even after being advised that it's the wrong precinct, they have that right. And in the past, and it could be that our records are wrong. The reason for that rule is that our records could be out of sync. They may have registered or updated the registration right about the deadline through the Secretary of State's office or through the mail, and for whatever reason, their record is not correctly reported in our records, or they may have been changed through the canvas, but then it turns out that the change of address was incorrect. So they've always had that right, and we give them that right to insist on voting in the wrong polling place. But as Mr. Scanlon noted, the rules have changed, as he detailed in September and October. And I don't want to characterize your remarks, but I think you even commented at the time to the board that this was a significant change of direction in the state law.
And it's not unusual when there's a significant change in kind of the procedural requirements in the election code that frequently what I call cleanup legislation is needed, where they don't realize the impact upon another section of the code that's created when yet an additional section is amended. So sometime the draftsmanship with a statute that's as complicated, and I say this all the time in many different contexts, as the election code, that amendments to one section that they won't realize it affects another section, and then subsequently there'll be the need for what I call legislative cleanup. This is the case where legislative cleanup is needed, and we're going to point it out, and I'm sure it'll be done.
And the other thing, too, to keep in mind is the statute, when it was amended, provided that ballots cast in the incorrect precinct would be counted in accordance with rules adopted by the State Board of Elections.
Yes.
So the legislature gave the State Board specific rulemaking authority to implement these new provisions. The State Board did adopt emergency rules prior to the March election. They are now in the process, I believe, of adopting and writing permanent rules. And all of those rules will go before the Joint Committee on Administrative Rules, which is a legislative oversight panel.
Yes.
So they get a chance to review the State Board's rules. I would hope they would take into account any changes they may need to make to the statute itself in the process of reviewing those rules.
Yes, and surely it's not this board's fault that these emergency rules went into place. And in fact, we did an investigation and proved that the Illinois State Board of Elections did not do their duty and properly inform the voters. They did not properly change any of the election judge manuals, so judges were not properly trained. And we asked them to give notice at the last minute, and they did not act on that request. So I'm familiar with the different problems that we have in implementing this. However, the fact remains, we have a process right now that I have actually already written a response to these notes, these comments, as Mr. Scanlon has referenced. So I don't know how many provisional ballots there were in Chicago out of precinct. I don't know how many people took a false affidavit, and as an election rights, organization.
It's not
I
a
am
false
concerned.
affidavit.
It is. If they said they live there and they don't, it's false.
But please,
It doesn't
Sharon,
mean that-
I think you have to be careful in how you characterize things.
Well, it's funny because the rules apply sometimes. And the issue of wanting people to vote, I care a lot about that.
I know you do.
And I care a lot about how the polling place is managed. And if
Yes.
you're training election judges, and what I did is I did a 4-county assessment of how these emergency rules were put in place. And I attempted to vote provisionally in Lake County, Cook County, McHenry County, and in Kane County, because I live in an area that has 4 counties in it, so I could do that. Everybody reacted differently, and the different election authorities interpreted how to implement the rules differently. And the reason that you have that problem is because the rules contradict the law. Now, Catherine Schultz said, absolutely not. If you do not live in this county, you cannot vote here. Other people said, well, you can vote, but your ballot won't count.
Are you saying that you applied to vote in 4 different locations?
Yes. But I didn't fill out any paperwork. I requested, I did what the voter is allowed to do. The law states if I have not voted.
I think you want to think about what you just said.
No, I don't think so. I didn't do anything illegal. The law states if I haven't voted yet, I'm allowed to request a provisional ballot. So I went in and I said, may I vote provisionally? And went through, never filled out any paperwork. Okay? It's just
Were you intentionally misleading an election official?
Absolutely not. I was intentionally requesting to exercise my right, which was to vote a provisional ballot.
In 4 different locations, in 4 different counties?
And I got turned down in one. I went to the next one. I got turned down. I went to the next one. So I went through the process as is legally prescribed, and I documented it, and I gave my answers to the Illinois State Board of Elections.
But did you try to vote first?
No.
And then were you denied? You just immediately asked for a provisional ballot?
Well, the law says I can insist. I can walk in the polling
But no,
place
first
and
you
say
have to
insist.
attempt to vote and then
No, there's
exhaust
nothing
your...
in the law that says that.
Wow.
It says I have to go in, and you see, it's even more dangerous, because I had the right to be in those polling places, even though I didn't have poll watching credentials, because I was a voter that lived in that district that could insist. It's true.
In all 4 districts, you lived in all 4 districts and had a right to vote in all 4
Barrington
districts.
Hills has 4 districts, honestly.
Yeah, but listen, Sharon, this is a public comment section. I'm getting into a dialogue with you, which is what I'm not supposed to do, so stop me, please.
Well, I think we have heard the issues and the concerns, and we've also heard about how we intend to bring the issues to the attention of the legislature and the State Board of Elections. And at this point, I think that we have said everything we could, and I would like to go ahead and make a motion to adopt and approve the tabulated statement of the returns and proclamation of the results of the canvass of the election returns for the March 18, 2014 general primary election.
Thank you.
Second that motion.
Thank you, Commissioner. Moved and properly seconded.